Okay, hello everybody. We're here on behalf of the International Labor and Employment Relations Association 10th Regional Congress of the Americas. We're calling it ILERA2020. And as you know, ILERA was meant to be held in the wonderful city of Toronto in Canada, but because of the pandemic, we have gone with an online conference. But we wanted to take the opportunity to recognize a number of people that won awards that are given by the Canadian Industrial Relations Association, CIRA. And one of those awards is the Law of Work Award. And the Law of Work Award is in its third year, and it was created through the excellent idea and generous donation of Dr. David Doorey. And David is an associate professor at the School of Human Resource Management at York University, and he is also the director of the Osgoode Hall Law School's part-time LLM program in labor and employment law. So always generous thanks to David for this award. And the award is to recognize exceptional scholarship in the area of Canadian employment and labor law. And it is for junior scholars and also for students. And this year we have a fabulous winner here with us, Cole Eisen. He is a student at the University of Toronto Faculty of Law. I should have checked with you, Cole, that's how you pronounce your last name.
Yes, you're spot on there.
Perfect, great. So yeah, Cole is at the U of T Faculty of Law, and his paper, which you will see in the program, so you can attend the session that Cole's going to be in to get more detail, is called The Dual Aspect of Unions, Public and Private Law Issues in the Context of Internal Trade Union Disputes. And Cole is with us here today, and we thought we'd have a little chat. So Cole, tell us a little bit about your paper, summarize some of its main elements.
Yeah, absolutely. So my paper addressed a topic which is something I've been thinking and writing about for some time now, and that's the law of internal union affairs in Canada. So in other words, that's the law that governs the relationship between union members as opposed to the relationship between the union and the employer. And for any of our international viewers here, our law in this area is sort of a hybrid between the American and English approaches, like a lot of things Canadian. And so basically all Canadian jurisdictions have adopted some version of the American Wagner Act to govern relationships between the employer and the union. And this outs the common law, but we have no equivalent of the internal governance rules that they have in the US. So internal union affairs in Canada is still governed as it always was at common law. And as I argue, this means that we have really two distinct sets of labor laws in Canada that are based upon completely different legal principles. So on one hand, there's the statutory collective bargaining law, and this is managed by specialized tribunals, industrial relations professionals, and it's all based around modern legal principles designed to facilitate collective power. And then there's this old common law of internal union affairs, which continues to be managed by common law judges, and it reflects notions of individual freedom and autonomy, which are really foreign to a modern collective bargaining regime. And, I argue in my paper that as a result, Canadian unions, at least from a legal perspective, have two distinct but overlapping legal faces. And what I set out to do was to create a principled approach to define the boundary between these two faces. So you can take a particular dispute and, figure out which forum it fits in and make sure that the right principles are being applied. And so this might seem really academic, but it also responds to what's actually a very practical problem. Over the past decade or so, anti-union stakeholders have recognized there's a legal uncertainty in this area, and they've been trying to sidestep a lot of the statutory protections Canadian unions have by bringing disputes that would properly be adjudicated at the Labor Board as an unfair labor practice forward in court. And what this does is it shoehorns a matter into the residual law of internal union affairs so that litigants are benefiting from more employer-friendly legal terrain. And obviously this is a very innovative legal strategy, but it could also seriously undermine some of the legal rights Canadian unions have acquired if it were left unchecked. So I try to marshal a set of legal and historical arguments that unions can invoke when they really need to tell judges to sort of butt out of our labor law and leave things to the Labor Board.
Fabulous, that's very interesting. And it's, as you say, it may seem like kind of a niche notion, but it doesn't seem to me that that's discovered very much in the literature or sort of in practice to date.
Yeah, it was definitely fun to work on. It required sort of thinking from the ground up and building a theoretical framework and then running a few issues through it. And one thing I've been trying to do and hope to keep doing is seeing what insights this two faces of, the Canadian Union idea can, where it can lead in other areas, in the collective bargaining relationship, in arbitration. So
definitely you see an impact for, as you said, for, kind of not union survival, but at least union strength, but I guess maybe also for, the experience of a member in unions. It may be kind of hard for them to navigate this law themselves, but also you could have, members within unions who might prefer one path or another.
Mm-hmm. Yeah, and I think it's really important to get this stuff clear, because otherwise what you're incentivizing is that, factions within a union sort of spend all this money in litigation, and the union ends up cannibalizing itself, and that doesn't really benefit any members. Unfortunately, that's something we have seen in Canada recently, and my paper was sort of inspired by some of the internal conflict in the labor movement here and charting a path forward. So we would have some very fair but predictable, reliable, principled ways to, resolve disputes.
Great, thanks, Cole. And you, Cole, and I were just chatting a little bit before we pushed record. And Cole has a background in industrial relations from McGill, and now is in the Faculty of Law. What piqued your interest in IR and then in going forward in labor and employment law?
Yeah, so out of high school, I got a union job, and I became very quickly involved in my union, and they were very supportive of me as I studied IR. And I really believe in the values that the labor movement represents. So for me, going into labor and employment law was a bit of a natural progression, and it's been a wonderful experience so far.
Fabulous. And where do you want to go next?
Yeah, so next month I'm actually starting work at a great union side labor law firm here in Toronto. And as we kind of alluded to, my favorite thing about IR and labor law is how it marries the theoretical and the practical so well. And so I'm really excited to cut my teeth with some really talented lawyers working on some emerging, exciting legal issues. But obviously, I also like the academic side of things, and I want to keep doing that. But I'm not really sure in which capacity I'll be doing that. So the short answer is I'm not really sure how I'll be doing that going forward. I'm a bit excited to be getting out of the academy a bit, actually.
It's nice to have a small break in the real world, I guess.
Definitely.
Well, and you can always, negotiate with your employer about the, some of the terms and conditions of your work.
Yes, yeah, I'm definitely capable of doing that, but I guess so are they. So I don't know what the negotiations would look like.
Well, congratulations on this award. It's really well deserved. And, we're really happy to have you here in the CIRA family. And definitely come and hang out at conferences with us. There are lots of other lawyers who keep their paw in the academic world and hang out with us at CIRA, and we're happy to have you. And of course, definitely check out future ILERA conferences. The next one is in Sweden next year, so it might be a very exotic location that we can all meet face to face.
Yeah, of course. Thank you so much, and it's an incredible honor.